Good afternoon, or evening, or morning, or some other time if you're on another planet or something like that. Not legal advice. Like, subscribe. So if you're watching this and you haven't subscribed, please subscribe. If you have subscribed, have somebody else subscribe. If your pet has not subscribed, please have your pet subscribe. I know they're clamoring for that. Before I start, I'm going to talk a little bit about our favorite man, Gary Gensler, and his performance yesterday, and a couple things I would ask him and a couple things I noted. But before I address that, I wanted to ask a question of everybody to see if they knew which capital city had the highest growth in population every year. The answer, of course, it's Ireland, and of course, the capital city is Dublin. Anyway, after that amazing joke. Yesterday, Gary Gensler testified before a House committee supervising his conduct. At some point in time, um, Representative Norman asked him a couple questions or a few questions about MMTLP. And I know I happened to be watching it at that point in time, so I saw it and I saw his response. And I saw that ultimately when he feigned again lack of knowledge, and then he indicated he knew who metamaterials was, and then he referenced, I think, Nextbridge, and then he referenced when asked about the consolidated share count, he said he believed that was publicly available, and he did not know the information. So that was kind of the background. And I was thinking about that, about how he got to that point in time. So what happens when I have a witness that's going to appear and going to be deposed? Because in essence, that's what Gensler is doing when he's appearing before Congress. In essence, he's giving testimony under penalty of perjury, and it's in essence like a deposition. So what happens when you prepare for a deposition? Now, first we have to recognize this is his second appearance before a panel. Prior was the banking committee, I think, and he was asked a bunch of questions and provided a bunch of documents and letters to review beforehand. So he already went through the first experience. After the first experience, he was sent some additional letters. Those included letters as to MMTLP. So he was asked about it the first go round. He was probably sent documents about it beforehand, and then he received letters about it afterwards. So I find it interesting that he wasn't specifically aware of those numbers or didn't want to disclose that numbers, because in essence, this is what would happen. He would meet with either his lawyers, in-house lawyers, being the general counsel and maybe somebody else is from the general counsel, or if somebody else was representing him, an outside firm, he would meet with that firm. And before he attended this particular proceeding, he would have been grilled on all the topics and subjects that they thought he might be grilled upon. They might ask him the specific questions. They might show him the specific documents. And obviously, letters, etc., that he received prior to after his last appearance would be documents and topics that someone would expect that they might be inquired upon on the second go round. So generally, you would go over all those materials. You would go over answers. You would let the witness answer, and then you might correct the answer or give them different ways of answering it, but you would thoroughly review that. And when somebody's testifying before Congress, I think that's even more emphasized. And you have to remember this guy is a Harvard educated lawyer. So, despite the fact we may not like what he's doing, he's no dum dum. And I doubt very much whether he lacked knowledge of these facts, because that wouldn't be consistent with um, his training and training for this proceeding. So that's one. Two, so in a lot of these responses to FOIA, et cetera, there's been a privilege that's been raised. Some of it is an investigation privilege, but there's been other privileges with regard to the share count, blue sheets, et cetera, confidentiality privilege, et cetera. So when GG was asked about it, he made no reference to confidentiality or privilege, even if he didn't know the answer, as opposed to saying, I believe that information is confidential or that information has to be kept private. He immediately went to thinking that the information was public. That's quite a distinction. So not only did he not reference confidentiality, but he referenced that he thought the information was public. And what's the significance of that? So if they being the SEC don't produce the documents, it would be inconsistent, I think, for them to now raise an objection on basis of confidentiality or some other basis, because our friend Mr. GG said it was public, and again didn't assert any type of confidentiality claim. So in legal parlance, you might claim that's a waiver, although that's an issue that would be litigated, whether it was an intentional relinquishment of a right. That's kind of the definition of a waiver. So somebody might have a right to something, but if they give up that right, that's a waiver, and they can't assert that as a defense. So maybe in this case, the SEC might be able to assert the defense that they're not obligated to release the share count information. But Mr. Gensler seemed to have taken a different position about that, and I think it really opens the door in future requests. Now, obviously, I'm trying to take Mr. Gensler's deposition in my arbitration, MMTLP arbitration. Today, I sent out another request for documents related to, I think, this specific topic. And it was an addendum to my third supplemental request for special discovery. But if I had Mr. Gensler in front of me, when I was asking the question about the share count and he feigned knowledge, I would ask him, I'd ask him specifically, did you prepare for this hearing here today? I'd ask him if he reviewed documents. I'd ask him which documents he reviewed. I'd ask him, since he was advised about MMTLP in the past, you were aware or you suspected they were going to ask you about MMTLP. And since your last appearance, you received documents related to MMTLP, because that's what was stated during the proceeding. I think Representative Norman indicated that, and Mr. Gensler didn't object to that. So, Mr. Gensler, you were provided documents. You've been asked about MMTLP, and anybody with a reasonable expectation could anticipate that you would be asked about it. But you seemed unprepared here today. Would you disagree with that? He would say yes or no. He'd say he was prepared, and I would say, if someone was really taking this seriously, I would expect that they would have reviewed information in regard to MMTLP, since you had been asked in the past, and you've been since provided documents about it. This is not a case, and correct me if I'm right or wrong. This is not a case where you intentionally did not prepare, right? You didn't want to be not prepared for this, so you didn't have to answer. Isn't that correct? Anyway, I'd go a bunch of questions about that, about his lack of preparedness and lack of knowledge. And then on top of that, I would say when he comes back to that nonsense about not testifying on behalf or suggesting he's not testifying on behalf or for the SEC, I would ask him, did you receive notice here today to testify as Gary? Is somebody asking Gary to testify, or is somebody asking the head of the SEC to testify here today? Which one is it? Because every time you say that you're not testifying or not speaking on behalf of the SEC, that's exactly what you are doing. And if you're not capable of speaking on behalf of the SEC, you shouldn't be here. And we could stop the hearing today, and if you want to have somebody else attend who's qualified to testify, then so be it. But if you're the head of the SEC and you're going to put yourself available in front of Congress, then damn well you be prepared in the future. Anyway, some of the stuff I would say, again, I think it's unbelievable that he didn't know the information, and clearly he's been briefed on MMTLP on multiple occasions. He's had lawyers talk to him about it. He's had staff talk to him about it. He's reviewed documents, and he knows the answers. So I appreciate him agreeing that that information should be public, and that, in essence, he's asserted that he's not going to be objecting. So let's push the subject to him. On top of that, since now he's asserted that, now's the time for a subpoena from the chairman. Let's go for it. I think it'd be really helpful to issue the subpoena. I think you'd give Gensler a couple weeks to comply voluntarily. And if he doesn't, you serve the subpoena. Let him assert his objections in light of his waiver or potential waiver, and let a court decide. And if he's not willing to produce documents after a court directs him or the SEC to, then follow all remedies that apply, whether that be a fine, jail time. It would require going to a federal judge. But whatever applied, pursue it. And I think that's ultimately the issue, is the Congress is very reluctant to use their subpoena power. In this case, since Mr. Gensler, and I think the chairman, indicated his growing tired about a lack of cooperation from the chair. Now's the time. Call him, have counsel call. Here's 2 weeks. Give us the documents. If not, we're serving a subpoena. Then you can go fight it. You can experience the embarrassment. You could deal with the ramifications. And, well, this is how we're going to play ball in the future. So that's how I would handle it. That's my thoughts about Mr. Gensler's brief testimony on MMTLP. Thank Mr. Norman for asking the question. And I look forward to the follow-up, if there is follow-up. Anyway, be well. That was my quick view. Take care. Have a good night.